All right, peace and blessings. It's March the 21st, Wednesday, 2018. Let's read Cesspool of Judicial Corruption, the David Hinkson story, page 251 through 300. Mr. Hoyt in, and that he was working on it even as we spoke. So I said, thanks for your efforts. Shortly after Mr. Hoyt, who was a former assistant prosecuting attorney, was taken into the cell area, his first observation was that attorney booth number 12 had no one in it during the remaining hour he was there, and after consulting with other attorneys he learned that it never had been occupied. No one had left and no one came in. Attorney Hoyt had emailed and faxed a request to visit David on Tuesday, July the 15th, 3 days earlier. Officer Sproul told me that an attorney needs to notify ADX 3 or 4 days before coming. So I told Mr. Sproul that he could then take one of our family social visits. Officer Sproul then told me that all 8 of the social booths were full. They did in fact get him in for an hour visit at 3:10 p.m. Mr. Hoyt called me telling me that all 8 of the social bays had been empty all along. At 3:25 p.m. I called ADX and asked to speak to Officer Sproul. Why did you lie to me? I asked. He told me that he had been informed that all the bays/booths were full. Who told you that? Officer Haygood, he said. I'll accept that, but then you were being lied to by Haygood. I tend to believe that Officer Sproul was telling the truth. I was angry, yet he remained cool. Quite cool. Haygood in the past has demonstrated inappropriate behavior toward both David and his attorney, Mr. Hoyt. Possibly he needs to be reminded of the Legal Resource Guide. Another issue that raised my ire was the fact that David had notified the ADX authorities 2.5 months previously about a tooth hurting him. When his face swelled up and he was agonizing in pain, medical at the facility gave him a limited amount of penicillin. They did not examine the tooth. I asked Officer Sproul to put me through to medical department. He started to give me a post office box number. I asked him if someone were hit by a car. Would you send a letter for assistance? I said I don't want help in 3 months or even 3 hours, but now. So he gave me the ADX telephone number 719-784-9464. I let it ring for 30 times before it shut off automatically and for another 20 rings before I hung up. I attached to the letter the appellate court decision on May the 30th, 2008. Trial held on May the 7th, 2007. Court remanding back for retrial David's conviction from Talman's court. I said, although it is highly unlikely that David Hinkson will remain in the custody of the ADX for much longer, all prisoners under your custody should be treated under the guidelines of the stated objective of the Bureau of Prisons. The following is what the BOP wants the public to believe. The Bureau of Prisons provides services and programs to address inmate needs, structured use of leisure and facilitate the successful reintegration of inmates into society. Each Bureau facility offers a set of programs and services that vary based on the characteristics and needs of its specific inmate population. Upon arrival at a new institution, an inmate is interviewed and screened by staff from the case management, medical, and mental health units. Later, an inmate is assigned to the admission and orientation program, where he or she receives a formal orientation to the programs, services, policies, and procedures of that facility. The program provides an introduction to all aspects of the institution. Research has conclusively demonstrated that participation in a variety of programs that teach marketable skills helps to reduce recidivism. Additionally, institution misconduct can be significantly reduced through programs that emphasize personal responsibility, respect, and tolerance of others. Accordingly, the BOP offers a wide variety of program opportunities for inmates that teach pro-social values and life skills. These programs include vocational training, the Life Connections, program parenting programs, and mock job fairs. With regard to the attached memorandum dated July the 21st, 2008, I question if ADX intends to comply with the guidelines and unequivocal demands as stated. Sincerely, Roland Hinkson. I followed up by calling our Colorado Senator's office. Senator Allard was by then a lame duck. He was leaving the Senate. Regardless, I had hoped he could help with David's plight, so I sent the following letter. Senator Wayne Allard, care of Brian McCain, August the 8th, 2008. Dear Senator Allard, recently I spoke to your assistants, Mr. McCain and Mr. Merritt, regarding law violations amounting to abuse of inmates by federal employees at 80 Max, Florence, Colorado, USBOP. I contacted Warden Wiley of the U.S. Penitentiary, but he has been unable to correct the abuse of inmates, which has now proven to be an ongoing stream of misconduct that needs investigation and correction. I am an investigative reporter for the American's Bulletin and other publications, as well as being a guest on talk shows regarding individual rights. My son, David R. Hinkson, was fraudulently convicted of solicitation of murder of 3 federal officials, which solicitation never occurred. All the so-called evidence was manufactured by a man that has since been convicted of defrauding the VA of over $100,000 in benefits using the same false evidence. This man's fraud was so pathetically flawed that the forged DD-214 he used to claim awards from the Korean War era showed medals that were not created until the 1990s. The Ninth Circuit Court of Appeals has reversed David's 2005 conviction. However, because of a petition by the Justice Department for en banc review, he continues to sit in 80 Max solitary confinement. The merits of David's case are not the issue here, but only magnify the injustice of the abuse at 88 Max. I am seeking your aid in correcting the willful violation of U.S. BOP rules and regulations by the guards at 80 Max, which can include the denial of right to legal counsel regarding pending proceedings and denial of right to reasonable dental care. David has had an abscessed tooth for nearly 3 months, which has been disregarded. A summary of these matters is attached. However, the extension of your good offices in addressing these problems, heretofore swept under the rug, is truly necessary and will affect other constituents as well. Sincerely, Roland Hinkson. It was no surprise that Senator Allard was unable to do anything. I believe it was mainly because of his short time frame left in office. By turning the spotlight on abusive behavior by government agents, police, prosecutors, and judges charged with carrying out the proper procedures that Americans believe in and expect can only strengthen our nation. Regardless of how tough the job is for the overseers, we citizens must always keep the light shining on them. For law enforcers to make deals with criminals to get convictions leads to corruption. Elitists in power in America today intimidate those we choose to serve us. To blow the whistle or deviate from their dictates can be fatal to careers. But we must again become a nation where law and order rule, not powerful men. Otherwise, we will not be citizens, we will become nothing but slaves. If police use informants and the police in fact violate any law in doing so, they must be charged and punished the same as any lay citizen. But how does this informant system work? Chapter 38. The rewards of testifying. It's hard to tell how long it'll take the Supreme Court to take David's case. But the issue is now of major magnitude because the Ninth Circuit has changed the standard, and it will reflect on future decisions in other cases. One informant lies with impunity. One judge appointed politically with the power to destroy anyone who comes into his or her courtroom with no reasonable way to appeal the decision can only lead to tyranny. By allowing a rule that a trial judge's discernment is final is fatal to justice. In David's case, we watched a process unfold that makes the term kangaroo court seem mild and innocuous. With millions of dollars spent by David and his family and by the taxpayers, with loss of Wateraz's potential income and shattered family members' lives, how can we feel that there is justice in this land of our heritage? About the time the parade against David was in its infancy, former Ohio Congressman Robert E. Bauman, J.D., wrote an article called Personal Privacy, the United States and Informer's Paradise, December 1997. He stated most Americans know little or nothing about the widespread domestic use of police informants, and few government and police officials are willing to talk openly about this big, dirty secret. It could be you being investigated or charged with crimes you didn't commit because an informant pointed the finger at you. The congressman explained, money laundering is one of the favorite charges pursued. Shrouded in secrecy, informers don't want publicity about their nasty work. They want lenient treatment for past crimes, money rewards, and sometimes revenge. Despite constant government efforts to keep the public in the dark, the bright sunlight of publicity has exposed the squirming mass under the rock. Further, Congressman Bauman gives details. In the wake of the 1995 Oklahoma City bombing, President Clinton quickly demanded that Congress pass legislation greatly increasing police wiretapping, FBI surveillance, and the expanded use and protection of government informants. He said that many of Clinton's dubious proposals found their way into law under the guise of anti-terrorism controls. He revealed that even 15 years ago, Michael Levine, a retired 25-year veteran of both U.S. Customs and Drug Enforcement Agency, DEA, estimates that there are currently at least 15,000 informers on federal payrolls, not counting many thousands more paid by state and local police. His estimate does not include more than 10,000 informants who claim money rewards each year for reporting fellow taxpayers to the IRS, or the nearly 1,000 so-called controlled informants the IRS pays to inform on others, some of them tax accountants. For example, for the fiscal year ending September the 30th, 1996, the IRS paid informants U.S. $3.5 million, nearly double what it paid for the previous year. How much was that in today's value? Levine, retired in 1990, complained that informants earned 3 or 4 times more money than their bosses. He said our rights as citizens and the U.S. Constitution are now in the hands of 15,000 wild, out-of-control informants. Former Congressman Henry J. Hyde of the House Judiciary Committee talked about government use of an army of well-paid secret informers whom he described as a motley crew of drug pushers, ex-cons, convicts, prisoners, and other social misfits. They have a strong incentive to lie, and they often do. Informants, by their very nature, are not normal, gainfully employed, honest, upright citizens. Rather, they are, or have been, involved in drug or other serious criminal activity, and their motivation is to save their own skins. Congressman Bowman gives some examples of how the system works. Typical is the 1996 New York Federal District Court case in which Ahmaud A. Salem, the unsavory main government witness in New York's World Trade Center terrorist bombing conspiracy trial, admitted he lied, testifying he was promised more than $1 million by the government for his assistance as the principal informer in the case. Informers are sometimes paid on a contingency fee. The total value of property they finger for successful forfeiture determines how much money the government pays into their personal bank accounts. Cooperating witnesses receive 25% of the value of property seized by the government in any one case, with a maximum cap of $250,000. A report of the U.S. House Committee on Government Operations showed how well informers are being paid. Even back in 1990-91, for example, the Justice Department paid 65 informants more than $100,000 each. 24 were paid between $100,000 and $250,000, and 8 got over $250,000 each. With the declining value of the dollar, you can estimate how much money that is in today's economy. But be aware, secrecy is the rule. Bowman shares other insights about how they are polluting our system. Although the Sixth Amendment part of the U.S. Constitution Bill of Rights guarantees an accused person the right to be confronted with the witnesses against him, courts have held this is not absolute and usually applies at trial, but not always in preliminary stages of investigation and indictment. These rulings, Bowman says, supporting the so-called informant's privilege, allow secret accusers to avoid risk of exposure by having to testify in public. Instead, a police officer seeking a search warrant simply repeats before a magistrate or testifies before a grand jury about what he was told by a reliable informant. This highly unfair result, most criminal defendants never find out who accused them of wrongdoing unless prosecutors decide an informant's testimony at trial is essential to convict. Prosecutors, police, and federal agents defend this system, arguing informants are indispensable in organized crime, terrorism, and white-collar crime cases. Harvard law professor Alan Dershowitz wrote in his book, The Best Defense, about little-known rules that govern the justice game in America today. Rule 4 is almost all police lie about whether they violated the Constitution in order to convict guilty defendants. That is certainly accurate, Bowman said, when it comes to the use and/or manufacture of police informers. It is now commonplace for police lacking a reliable informant on which to base a request for a search or arrest warrant to invent them. Lying by police to support questionable criminal charges against suspects has gone on for years in New York City, according to a report of the Mayor's Commission investigating police corruption. After 1993 through 94 hearings, the Mullen Commission concluded New York police routinely made false arrests, invented informers, tampered with evidence, and committed perjury on the witness stand. Perjury is the most widespread form of police wrongdoing. The report stated, noting it even has a well-known nickname among the courthouse, cognoscentia testilying. Mr. Bowman sums up his article with thought-provoking observations. He wrote, Congressman Hyde believes most Americans don't realize the extent to which our Constitution protections have been violated and diminished in recent years. Neutral observers, libertarians like the Cato Institute, political conservatives like Hyde and Judge Trott have joined with liberals and others on the left like Professor Dershowitz and Philip S. Gudis, Media Relations, Director of the American Civil Liberties Union. They believe unchecked police informant use constitutes a serious danger to individual liberty. While the public only learns about major informant cases that go wrong, there are thousands of accused persons fingered by a friend for a crime they did not commit. Carefully controlled use of informants has a place in proper law enforcement. But what kind of justice is it when prosecutors boast of charges against a businessman whose employee or associate settles a score with any anonymous accusation of criminal conduct? Betrayal is an essential element in the government-police informant game, but the repeated betrayal of basic constitutional principles guaranteeing our freedom is the real menace to society. Late Supreme Court Justice Louis D. Brandeis warned, the greatest dangers to liberty lurk in the insidious encroachment by men of zeal, well-meaning but without understanding. U.S. government agents may boast of cleverly turning criminals into instruments of law enforcement, but in this crude process, law officers have become willing co-conspirators in crime and too often criminals themselves. What if prosecutors, judges, and government agents get bonuses for arrest and convictions? Would these people be chasing dollars rather than serving justice? Chapter 39. Do prosecutors and judges get paid? Is there something wrong with this scenario? I downloaded a promo from the internet about a book written by Phyllis Schlafly, B-A-M-A-J-D. She wrote a book called Protect America from Judicial Tyranny, The Supremacist, the Tyranny of Judges and How to Stop It. In her book, she refutes the two colossal myths propagated by the legal community for the last 50 years. 1. The Constitution is whatever the Supreme Court says it is. And 2. Court rulings are the law of the land. Her publishers describes Miss Schlafly's book, The Supremacist, as a dramatic page-turning account of what the judges have done to America in areas of religion, patriotism, marriage, schools, pornography, law enforcement, history, national identity, and even our right to self-government. This is a book about the fundamentals of American constitutional government and how we can shake loose the arrogant, arbitrary rule of judges before it is too late. She explains in her book why judges should be like baseball umpires, how the Supreme Court invented new rights without any constitutional basis. It is scary evidence judges use wild cards to create new law. Evolution doesn't just refer to the origin of species, it means that the supremacists evolved the Constitution into approving their own social policies. The judicial supremacists are also carried away with their importance that one judge declared a federal law unconstitutional because it called on judges to give information to Congress that might cause judges to be criticized. The Supreme Court plunged into a political thicket that courts are not supposed to enter. One judicial supremacist proclaimed that the Supreme Court is the ultimate interpreter of the Constitution, but the American people have never approved this concept. Congress has the constitutional right to tell the federal courts what cases to hear and what not hear. You'll observe later in this book where I place the real emphasis on judicial calendars. It has less to do with justice and more to do with money. Pat Shannon, American Free Press writer, wrote about payoffs to select government personnel, including judges. Anyone who has ever attended an Internal Revenue Service court case likely noticed the biased attitude of the presiding judge in favor of the prosecution. Perhaps, though, only those of us who have sat in courtrooms in every section of the country can attest to this unwavering pattern of unfairness. Whatever happened to the judge's impartial role of referee? Federal statutes show how and why the U.S. law encourages prosecutorial and judicial conflicts of interest, non-neutrality, non-impartiality, and corruption of justice in the federal courts. How can the federal judiciary be independent and impartial when the law permits the federal government to secretly award judges up to $25,000 in undisclosed secret cash awards and to privately, secretly, and erroneously overpay them up to $10,000 and waive these erroneous overpayments? How can any defendant be found innocent or guilty beyond a reasonable doubt when such statutory cash award provisions on their face create an irrefutable behind-the-scenes incentive for the prosecution. This would include U.S. District Court judges and U.S. attorneys. The Mungovan suit, composed by Utah lawyer Dr. Dale Livingston, explains, these awards include secret cash awards. They are not limited as to the number of awards that may be awarded to any one person or group. There is no limitation placed upon any award. Any person or group of persons can be awarded this money, including U.S. attorneys, federal judges, President of the United States, or anyone else for that matter. Cash incentives paid for convictions help us understand not only what has happened in the past, but also what can expect to see in the future. Then there's a lot of footnotes on the bottom of page 265. I'll let you guys read all of those. They're quite small and quite long. I don't know if the government paid off Judge Talman or whether any of the prosecutors fell under this legal scam, but I do know that Talman awarded Stephen Hines and Nancy Cook rewards. That much is in the record. No one I've spoken with has ever heard of any of these general immunities pertaining to prosecutors, judges, and government agents passed by the courts in America. Many of our government now consider the Constitution as an obsolete historical document useful to make people believe they have rights. Yet prosecutors may violate civil rights in initiating the prosecution presenting a case. See United States Supreme Court in Embler v. Pachman, 434 U.S. 409, 1976. Immunity of certain government agents extends to all activities closely associated with litigation or potential litigation. See Second Circuit Federal Court of Appeal in Davis v. Grusmeyer, 996 F.2D, 617, 1993. As we observe in David's case, prosecutors may knowingly use false testimony and oppress evidence. See United States Supreme Court in Embler v. Pachman, 434 U.S. 409, 1976. Prosecutor may file charges without any investigation, as they consistently did in David's case. For example, Mariana Raff said David hired her brothers to kill the trio, but FBI agent Long never even so much as made a phone call until under pressure for 17 months. He already knew it was a phony. Also see 8th Circuit Federal Court of Appeals in Myers v. Morris, 810 F.2D, 1337, 1986. A prosecutor may file charges outside of his jurisdiction. See 8th Circuit Federal Court of Appeal in Myers v. Morris, 840 F.2D, 1337, 1986. Yet it is constitutionally unlawful. A prosecutor may knowingly offer perjured testimony, as Michael Sullivan did in David's case. See 9th Circuit General Court of Appeal in Jones v. Shankland, 800 F.2D, 1310, 1987. A prosecutor and apparently also a judge, as with Talman, can oppress exculpatory evidence. 5th Circuit Federal Court of Appeal in Hensel v. Gerstein, 608 F.2D, 654, 1979. And finally, we learned something that even most attorneys don't know. They certainly aren't taught this at law school. Prosecutors are immune from lawsuit for conspiring with judges to determine the outcome of judicial proceedings. See 9th Circuit Federal Court of Appeal in Ashelman v. Pope, 793 F.2D. What they are doing in the courtroom is all commercial and is in conformity to 27 CFR 72.11, where it confirms that all crimes are commercial. What the judge and prosecutor are doing in the courtroom is making a commercial presentment. This is a highly complex concept to comprehend. Regardless of the provisions in 42 U.S.C. 1983, there are only two procedures available if the judge and prosecutor decide to steal your assets or throw you in prison. 1. Impeach the judge, very expensive and unlikely to happen. 2. Appeal to a higher court. What happens if the upper court refuses to take the case? You can spend a fortune to overturn the decision based on a potpourri of judge-made laws. Judges profess the right to interpret the law and meaning behind the words. Justice in America is not cheap. On the internet, I came across an article by Llewellyn H. Rockwell, Jr. that I found enlightening. Americans, perhaps like all people, have a remarkable capacity for turning out unpleasantries that do not directly affect them. It's an astonishing fact that the United States has become the world's most jail-loving country, with well over 1 in 100 adults living as slaves in a prison. Building and managing prisons and locking people up have become major facets of government power in our time, and it is long past time for those who love liberty to start to care. Before we get to the reasons why, look at the facts as reported by the New York Times. The U.S. leads the world in prisoner production. There are 2.3 million people behind bars. China, with 4 times as many people, has 1.6 million in prison. In terms of population, the U.S. has 751 people in prison for every 100,000, while the closest competitor in this regard is Russia with 627. The median global rate is 125. What's amazing is that most of this imprisoning trend is recent, dating really from the 1980s, and most of the change is due to the drug laws. He discloses alarming data. From 1925 to 1975, the rate of imprisonment was stable at 110, but then it suddenly shot up in the 1980s. There were 30,000 people in jail for drugs in 1980, while today there are 500,000. Other factors include the criminalization of nearly everything these days, even passing bad checks or the pettiest of thefts. And the judges are under all sorts of minimum sentencing requirements. Now, before we move to causes and answers, please consider what jail means. The people inside are slaves of the state. They are captured, held, and regarded by their captors as nothing other than biological beings that take up space. The delivery of all services to them is contingent on the whims of their masters, who have no stake in the outcome at all. Now, you might say that this is necessary for some people, but be aware that it is the ultimate assault on human dignity. They are paying the price for their actions, but no one is in a position to benefit from the price paid. They aren't working off debts, compensating victims, or struggling to overcome anything. They are just doing time, costing taxpayers almost $25,000 a year per person, and they become socialized into this mentality that is utterly contrary to every notion of civilization. Then there is the relentless threat and reality of violence, the unspeakable noise, the pervasiveness of every moral perversity. In short, prisons are hell. It can be no wonder that they rehabilitate no one. It is expensive. States alone spend $44 billion on prisons every year. Inefficient, brutal, and irrational. It is also manipulated by political passions rather than a genuine concern for justice. The drug war itself cost taxpayers $19 billion, even as the cost of running the justice systems are skyrocketing up 418% in 25 years. People say that crime is down, so this must be working. Well, that depends on what you mean by crime. They are crimes because the state says they are crimes, but they do not fit within the usual definition we find in the history of political philosophy, which centers on the violation of a person or property. A more telling point comes to us from political analysts, who observe that the politicization of judicial appointments in the United States, judges run on their tough-on-crime records or are appointed for them, and so have every incentive to lock people up more than justice truly demands. One factor that hasn't been mentioned so far in the discussion is the lobbying power of the prison industry itself. The old rule is that if you subsidize something, you get more out of it. And so it is with the prisons and the prison industrial complex. I've yet to find any viable figures on how large the industry is, but consider that it includes construction firms, managers of private prisons, wardens, food service providers, counselors, security services, and 100 other kinds of companies. What kind of political influence do they have? Speculation here, but it must be substantial. As for public concern, remember that every law on the books, every regulation, and every line in the government codebook is ultimately enforced by prison. But won't crime go up if we abandon our prison system? Let Robert Ingersoll answer. The world has been filled with prisons and dungeons, with chains and whips, with crosses and gibbets, with thumbscrews and racks, with hangmen and headsmen. Yet these frightful means and instrumentalities and crimes have accomplished little. It is safe to say that governments have committed far more crimes than they have prevented. In David's case, did the government agents commit a crime, or did they carry out their duties lawfully? Chapter 40, the U.S. Constitution versus targeted individuals. Our Constitution is the foundation of all laws of the United States of America. Article 6 of the Bill of Rights clearly states, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and the accused shall be informed of the nature and cause of the accusation, and the accused shall be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. How did David's experience relate to this doctrine? The government incarcerated David for nearly 2 years without charging him in the threats case. They moved him from northern Idaho, where he lived and where the accusations had emanated, Moscow, Idaho, to Boise, Idaho, where the media had published so much hate propaganda that the feds handed to them. They did not inform David during the period of the nature of his crimes. The second lying accuser, Swisher, replaced the first thieving accuser, Raff, while David remained many months in custody. Judge Talman denied testimony by some of David's witnesses before the jury, even though we, David and family, paid for the witnesses to fly long distances. The fact that he wasn't in the United States when the second accuser, Swisher, testified that David plotted to kill government agents made no difference. The judge would not allow jurors to see his passport, even though David was in Russia at the time. Certainly this story sounds excessive, but the truth can be very disturbing. This book proposes to reveal events as they occurred. I did not write this book for the average audience where entertainment is the goal. Hopefully the reality of David's ordeal will open the eyes of those who yet feel comfortable with our current system of justice. The reader should understand that the conspiracy pervades at every level of the government. Certain techniques have been employed to circumvent the U.S. Constitution, and new laws are selectively enforced against targeted individuals. It does not matter if the targeted individual is innocent and never broke any law. What counts is that the government can always find someone desperate enough to tell a few lies and fabricate a story so that they can receive a reward. Oftentimes it will be the reduction of the cooperating witness's sentence by a few months, but it is always enough to get the person to lie about the target. The true role of government is to protect the rights of the citizens. Misunderstanding by prosecutors and judges of our adversarial system contest trials leads to abuse. Currently there is little that an accused can do to save himself or herself unless there are strong political connections or abundant money. In America today, you get as much justice as you can afford, but even then, if the system wants you, no amount of money will save you. However, if you give up, you are embarking on a hopeless life in slavery or imprisonment. I'm a realist, but I'm sure that there are at least a few insightful persons in the public who will join in David's struggle to regain his freedom. For the righteous and honorable to prevail doesn't depend on much on one's ideas or abilities, but on the courage one has to take risk and to act. Mark Twain wrote, "In the beginning of change, the patriot is a scarce man, and brave and hated and scorned. When his cause succeeds, the timid join him, for then it costs nothing to be a patriot." We could not help but to wonder if there were any judges in the Ninth Circuit concerned more about justice than their political careers, or if they stood on principle rather than on camaraderie with fellow judges. However, after a considerable wait, we got the news. Chapter 41, Three-Judge Panel of the Ninth Circuit Court of Appeals. To save a little money, Faye and I drove our road trek camper from Ouray, Colorado to Seattle, Washington, round trip over 2,000 miles. We arrived May 7, 2007. Joining us were Dennis Reardon, who flew in from San Francisco, California, and Curtis Smith from Idaho Falls, Idaho. We came expecting to hear Attorney Reardon plead David's case before the three judges for about 20 minutes. Fortunate the judge gave him a little longer. For us, costs were sizable considering we had to pay for attorney flights, food, hotel costs, all for a few minutes to answer questions. The Justice Department flew in from Washington, D.C., Michael D. Taxay, Counterterrorism Section, and Alan Hetchkoff and Alyssa Hart from the Tax Division. United States Department of Justice. Cost to the taxpayers means nothing to the government. All the appellate court could consider was the record. They permit no other related input. The lies told by Harding and Bates, the Gunderson plot, the participants never came to light. The only issue was, did David get a fair trial? Ninth Circuit Court of Appeals Judge William A. Fletcher wrote the majority opinion of the three-judge panel, which also included Judges Proctor Hugg Jr. and dissenting Judge Margaret McEwen for the hearing. He said, following a 2-week trial in federal district court in Boise, Idaho, a jury convicted David Roland Hinkson of soliciting the murder of 3 federal officials. The government star witness supporting the conviction was Elvin Joe Swisher, wearing a Purple Heart lapel pin on the witness stand. Swisher testified that he told Hinkson that he was a Korean War combat veteran and that Hinkson was impressed by Swisher's military exploits, solicited him to kill the officials. David never said this, nor was there any corroboration by any other witness. The source was strictly Joe Swisher. On appeal, Hinkson made 3 arguments. First, he argues that the district court wrongly precluded him from introducing evidence showing that Swisher presented a forged document and lied on the stand. Second, he argues that the prosecutor engaged in misconduct when he invoked Swisher's military record in his closing argument. Third, he argues that he is entitled to a new trial based upon his discovery after trial of evidence that conclusively establishes Swisher's fabrications. We hold that the district court abused its discretion in denying Hinkson's motion for a new trial. In response to our queries during oral argument, the government's attorney sent us a post-argument letter stating that he had been informed that investigating agents on the prosecution team first saw and learned of the Dowling letter on January the 18th or 19th at the Boise, Idaho office of Department of Veterans Affairs, emphasis added. There is no indication in the record that defense counsel had any idea the existence of the Dowling letter until the government provided it to the court on January 21st. Later that same day, the court received Swisher's official military file, a half-inch thick stack of materials from the National Personnel Records in response to its subpoena. Outside the presence of the jury, the court stated that a quick review of the file indicates that Mr. Swisher was in fact involved in top-secret activities, and it appears that he was awarded the medals that he claims that he was awarded. The court talman told counsel that it would conduct a more thorough review of the file over the weekend. When the trial reconvened on Monday, January 24th, the court went through Swisher's official military file with counsel off the record. Then, on the record and without the jury present, the court stated its conclusions. The file had been sent to the court by the National Personnel Record Center in response to the court's subpoena. The Dowling letter in the file matched the letter provided to the court by the prosecution on Friday, and the Dowling letter concluded that the replacement DD-214 and the supporting letter purportedly signed by Woodring were not authentic. But the court found the file very difficult to decipher. The court stated, "It is not at all clear to me what the truth of the matter is, and I suspect it has something to do with the fact that we are dealing with events that occurred 50 years ago." The court stated that the problem the court had in reviewing the documents in camera is that the documents we have themselves are neither self-authenticating nor self-explanatory. The court concluded, and I do not want to turn this issue into a peripheral mini-trial under Rule 608B of the Rules of Evidence. Defense counsel told the court that he was concerned about the government got the Dowling letter, which the prosecutor had provided to the court on Friday morning, January 21st. The court agreed that it was not at all convinced yet that the document that Mr. Swisher pulled out of his pocket was false or not. Because Swisher's military record was not self-explanatory, the court stated, "I have no idea if somebody is involved in secret military operations, whether or not their personnel file would ever reflect those missions." The court stated that it needed to hear from a records custodian from the National Personnel Record Center or someone else who is more familiar with military records and decorations than any of us. The court ruled that the defense would be permitted to recall Swisher for further cross-examination, but would not be permitted to introduce any of the documents bearing on his military experience. As Judge Fletcher pointed out, only one witness corroborated Swisher's testimony that Hinkson had been interested and impressed by Swisher's military background. That witness was Richard Bellon. Bellon testified that Hinkson wanted to hire Joe Swisher as a bodyguard. He felt like he needed to hire Swisher because he was trained. Indeed, Bellon testified that Hinkson's interest in Swisher's military background and skill in firearms stemmed from his interest in using Swisher as a bodyguard. Let's not forget that Richard Bellon was absolutely furious when Judge Bradbury ruled against him in the attempted takeover of Wateroz. Bellon brought Swisher into the coup d'etat along with the others during the Wateroz takeover. However, Judge Fletcher said there is evidence from both Swisher and Bellon that Hinkson believed the story. But the evidence specific to these counts differed in some respects. What utter nonsense to believe now that what Bellon had to say about David wanting to hire a man who was wheelchair-bound, sickly with a dangling catheter, and recovering from heart surgery to become his bodyguard at all because Bellon said so is beyond ludicrous. Why would David even want a bodyguard? Talman had paid no attention to the fact that the jurors acquitted David of all the charges based on the testimony of Harding, Bates, Birmingham, Bellon, Raff, and the other money grubbers. Certainly David was outspoken and called things as he saw them. The thefts, lies, and attacks were unrelenting. Judge Fletcher restated the testimonies of the above accusers. Witness after witness testified to Hinkson's express intense desire that Hines, Cook, and Lodge be tortured and killed. Lonnie Birmingham, a Wateroz employee and close friend of Hinkson, interesting how all these people claim to be close friends of David, testified that Hinkson had told him that he wanted Cook, Hines, and Lodge killed because he felt they were conspiring to come after him to destroy him. Bellon testified that he talked with Hinkson for hours on end about Hinkson's belief of a government conspiracy against him. Also of interest is that Rich Bellin declared under oath that he had a large box loaded with tape recordings of every telephone conversation he had with David, but no mention of wanting to hire anybody to kill anyone. Bellin described Hinkson's anger toward the officials prosecuting him as central focus of his life. Inasmuch as the FBI made no authentic investigation, no information surfaced about what was really going on. The government brought in to testify anyone who had something negative to say about David. During the FBI and IRS investigations, any potential witness who refused to badmouth David was summarily dismissed. The whole intent was to get a conviction, not learn the truth. The federal government threw at David anything they thought could conceivably stick. Appellate Court Judge Fletcher concluded, "We review a district court's denial of a motion for a new trial based upon newly discovered evidence for abuse of discretion. A district court abuses its discretion when it makes an error of law, when it rests its decision on clearly erroneous findings of fact, or when we are left with a definite and firm conviction that the district court committed a clear error of judgment." Judge Fletcher discussed a 5-part Harrington test the appellate court used to determine if they should grant a new trial. Judge Fletcher said, "After Talman's reading the half-inch thick file received on January 21st from the National Personnel Records Center, Talman concluded, it is not at all clear to me that the truth of the matter is. He said that the file was very difficult to decipher and not self-explanatory. Yet the Miller and Woodring affidavits were precisely the evidence that the district court and the prosecutor on January 21st had described as fatally lacking. The Miller affidavit provided precisely the explanation the district court had said it needed to decipher the documents in Swisher's file. Under the second part of the Harrington test, we asked whether the failure to discover the evidence sooner resulted from a lack of diligence on the defendant's part. A court cannot conclude that a defendant lacks diligence merely because a defense team with unlimited time and resources might have managed to discover the evidence sooner. Instead, mindful of the constraints and competing pressures on the defense before and during the trial, a court asked whether it was unreasonable for the defense to have failed to discover the evidence more promptly. The district court concluded that Hinkson had not been sufficiently diligent in discovering the new evidence. If Talman wrote, the court finds that the defendant is unable to establish that the failure to discover this evidence was not due to his counsel's lack of diligence. The court finds that the defense counsel had ample time to investigate Swisher's record prior to trial, but was not diligent in pursuing the issue. It is true, as the district court wrote, that Swisher gave grand jury testimony in 2002 and early 2004. But the district court was wrong to rely on the dates of the grand jury testimony. The government knew about Swisher's grand jury testimony, and thus the government was put on notice in 2002 and 2004 of his claimed battlefield injuries. Judge Fletcher said that Talman agreed to subpoena Swisher's military file and review it over the weekend. It arrived 2 days later on Friday, January 21st, and disclosed it to counsel on Monday, the last full day of testimony before closing arguments. Fletcher further said the district court's ruling precluded the defense from introducing into evidence any of the documents received by the court in response to its subpoena. Having already been embarrassed once by Swisher, defense counsel was understandably reluctant to attempt another cross-examination under the conditions imposed by the court. The district court made it quite clear that in its view the dispute over Swisher's military record concerned a collateral impeaching matter, and that Hinkson would not be permitted to introduce anything into evidence that would show that Swisher had lied about his military record, including documents from Swisher's official personnel file. It also stated clearly that it did not want the government experts testifying about Swisher's records. If the district court would not allow into evidence documents from Swisher's personnel file because they addressed a collateral issue, and if it did not want testimony from government experts, it is obvious that it would not have permitted live testimony of defense experts on the same issue. Although the district court's evidentiary ruling under Rule 403 was almost certainly not an abuse of discretion, its ruling under 608B was almost certainly legal error. The court, Talman, concluded that it was not at all convinced that it had enough evidence to resolve the question of whether or not the document that Mr. Swisher pulled out of his pocket is false or not. The court remained uncertain at trial about the truthfulness of Swisher's testimony and the authenticity of replacement DD-214. Despite the fact that Swisher's military file was a government record that the court itself had subpoenaed, and despite the fact that the file contained the Dowling letter, in sum the court stated at trial that the evidence before it was insufficient to allow it to determine the truth or falsity of Swisher's evidence. In its order denying Hinkson new trial motion, the district court wrote that the proffered evidence, the Miller and Woodring affidavits, is impeachment evidence and so is not a valid basis for a new trial. Now comes the dissenting judge, Margaret McEwen. She said, I object to the majority's effort to override the district court record. The district court was open-minded as to how to address the military commendation issue, recognizing that defense counsel opened the door and that ordinarily under the rules you are stuck with the witness answer and the court has the discretion to restrict further collateral proof of that impeachment. The court nonetheless suggested that counsel could continue cross-examination. The court also stated that another option would be to instruct the jury to disregard the testimony relating to the Purple Heart. Even during trial, once more facts came to light, counsel could have subpoenaed witnesses on this subject, but it chose not to, a strategic decision, which means that an innocent person must remain in prison for life because of a poor choice of counsel. That cannot now be the basis of the grant of a new trial motion. The district court Talman had first-hand experience with the discovery chronology and the diligence of defense counsel, regardless of his participation with the prosecutors. We mustn't question Talman's motive. After all, he's a judge. Nothing supports the majority's rejection of the district court's explicit findings regarding lack of diligence. The appellate court published its verdict on May 30th, 2008. Hooray! Now David gets a fair trial, and everyone knows that they won't retry him because they have no case without Swisher. But the Justice Department had an option. If not satisfied with the verdict of the appellate court under the rules, they are permitted to appeal to an even higher court called an en banc court. Means with all the judges for the circuit. An en banc court in the Ninth Circuit is composed of 11 judges, even though since it is the largest in the U.S. with 48 judges. Why I theorized would the Justice Department want to expose themselves to charges of corruption and bias to be held up to ridicule if the public should get wind of their fraud. I believe that the Justice Department would not fight the appellate decision because to do so would be stupid. David's main concern when we told him the outcome of the hearing, how soon can I get back to my work? Associated Press writer Todd Dvorak reported the decision. Boise, Idaho AP. A federal appeals court has overturned the conviction of a North Idaho businessman accused of plotting to kill a federal judge, prosecutor, and tax agent who were involved in a tax case against him. A 3-judge panel in the Ninth U.S. Circuit Court of Appeals found that a key witness in the 2005 trial lied under oath. In a ruling filed Friday, the appellate panel ordered that Hinkson deserves a new trial because the government star witness Elvin Joe Swisher, 71, forged documents used at trial and lied under oath about his military background. It's the most extraordinary case I've seen because the government has since then prosecuted and convicted its main witness for doing what he did on the witness stand. Dennis Reardon, the San Francisco-based attorney who represented Hinkson before the appeals court, told the Associated Press. He was the only witness who testified that Hinkson had asked Swisher to murder these federal officials. He said Hinkson asked him because he was a military hero and a real killer, but he was a fraud. A lower court denied Hinkson's initial appeal, but Ninth Circuit judges William Fletcher and Proctor Hugg Jr. found the lower court ruling flawed. Because Hinkson's conviction substantially rests upon the testimony of a witness who had been conclusively shown to be a forger and a liar, we hold that the district court abused its discretion in denying Hinkson's motion for a new trial. The majority opinion said. Judge M. Margaret McEwen disagreed, saying exposing a witness as a liar on a collateral issues is not grounds to overturn a murder-for-hire scheme corroborated by other witnesses. Witnesses such as Bates, Harding, Birmingham, Bellin, etc., where the jurors don't believe their testimony and acquitted David. The question in this case is whether David Hinkson solicited Swisher to murder federal judge and other public officers, not whether Swisher lied about the military service, she wrote. A spokesman for the U.S. Attorney's Office in Boise expressed disappointment in the ruling. Assistant U.S. Attorney Rafael Gonzalez said government lawyers must decide whether to ask a full panel of appeals court judges to review the decision. Chapter 42, 11-Judge en banc appeal. Of course, we knew there was a lot at stake in this trial. The Justice Department got their hair cut with the huge expenditure of taxpayer money of no significance to them by stymieing their ability to sustain a conviction with only one cooperating judge without allowing the convict a reasonable chance for appeal was paramount. If only they could grind us down, deplete all our resources, they win. Maybe you aren't aware, but the prison industry is huge. Unbelievable money is at stake. So it was worth the Department of Justice's time and resources to go again for the brass ring. With the same tenacity they applied originally in getting a conviction, the U.S. Attorney's Office decided to exercise their option for an en banc hearing. No question in our minds, obviously. This was a political decision from on high. So be it. Now we would have to wait another year or so to get confirmation that David would be free. In the meantime, David languishes in a solitary dungeon. I often wonder how these people can sleep at night or face a mirror. A year and a half later, December the 15th, 2008, after the appeal victory in Seattle Fay, I drove to Pasadena, California for the 11-judge en banc hearing. We met Wes and Sandy Hoyt, Dennis Reardon, and Curtis Smith at 6 p.m. for dinner. We discussed Dennis's strategy. Next day at 1 p.m., we arrived at court chambers in Pasadena. John F. Depew and Michael D. Taxay from the Department of Justice, Washington, D.C., came shortly after we took our seats on a bench. There were a few other observers, mostly students, who sat down on rear benches. At 2 p.m., a curtained stage opened and all 11 judges filed and taking seats in 2 rows, all clad in black robes. The following judges took their seats: Alex Kozinski, Chief Judge; Harry Prigeson; Damarid F. O'Scanlan; Andrew J. Kleinfeld; Kim McLean Wardlaw; William A. Fletcher; Richard A. Paez; Consuelo M. Callahan; Carlos T. Bay; Sandra S. Ikuta; and N. Randy Smith. There were more judges than observers. We had been patiently waiting while squirming on the hard bench. Off at the far right end of the room, Mr. Depew sat unengaging. Our erstwhile adversary, Mr. Taxay, came into the room just before the command, "All rise." Dennis Reardon gave an excellent and compelling summation of the case. Several of the judges asked questions, but demonstrated that they weren't of one opinion. Others were silent throughout the hour. By contrast, Depew and Taxay argued pathetically from a rehash of all the same old judge-made laws. We felt confident that the judges would unanimously sustain the 3-judge appellate decision. Months passed before we heard the verdict. Judge Carlos Bay wrote the majority opinion. Today we consider the familiar abuse of discretion standard and how it limits our power as an appellate court to substitute our view of the facts and the application of those facts to the law for that of the district court. David Hinkson refused to pay income tax on his business profits. False statement. David challenged the authenticity of the tax code, but gave full authority via power of attorney to take any amount due. He asserted the United States Constitution forbade the federal government from taxing a person's income. David's assertion was a correct statement. Government can tax lawfully only corporate income. He was investigated by Internal Revenue Service agent Stephen Hines, prosecuted to a conviction for income tax evasion by United States Attorney Nancy Cook, and sentenced by United States District Judge Edward Lodge. False. He was sentenced by Judge Richard C. Talman. While awaiting trial on his tax evasion case, Hinkson solicited his friend and employee Elvin Joe Swisher. He was never an employee at Water Oz. At the time Swisher alleged that David solicited him, David would have nothing to do with him, to torture and kill Hines, Cook, and Lodge for $10,000 per head. Swisher reported Hinkson's solicitations to federal authorities only after we refused to pay him $5,000 or comply with his blackmail. Hinkson was indicted, tried, and convicted by a jury for solicitation of the murder of the 3 federal officials. Swisher testified on behalf of the government. The government had full knowledge that Swisher was a fraud. Hinkson then moved for a new trial, principally on grounds that Swisher had fraudulently presented himself to Hinkson, and later to the judge and jury as a Korean War veteran and experiencing and killing people. But he had no such war service nor experience. In brief, Swisher had falsely held himself out to be a war hero. The trial court denied the new trial motion. Hinkson appealed this denial of his new trial and motion and several evidentiary rulings made by the trial court. We granted an en banc review of the panel's decision to reverse the district court's denial of Hinkson's new trial motion, and for the reasons explained below, we conclude that our abuse of discretion standard is in need of clarification. The standard, as it is currently described, grants a court of appeals power to reverse a district court's determination of facts tried before it and the application of those facts to the law if the Court of Appeals forms a definite and firm conviction that a mistake has been committed. At the same time, the standard denies a Court of Appeals the power to reverse such a determination if the district court's finding is permissible. How do they define this word? It has previously been left to us to decide without further objective guidance whether we have a definite and firm conviction that a mistake has been committed or whether a district court's finding is permissible. There has been no effective limit on our power to substitute our judgment for that of the district court. In other words, We have the authority and power to choose any interpretation of words or meanings of words we want, even if illogical nonsense. Today, after review of our cases and relevant Supreme Court precedent, we restate the abuse of discretion standard of review of a trial court's factual findings as an objective two-part test. As discussed below, our newly stated abuse of discretion test requires us first to consider whether the district court identified the correct legal standard for decision of the issue before it. Second, the test then requires us to determine whether the district court's findings of fact and its application of those findings of fact to the correct legal standard were illogical, implausible, or without support in inferences that may be drawn from facts in the record. The key phrase here is facts in the record. If a trial judge denies the jurors from hearing the facts and exculpatory facts are withheld, they will never become part of the record. No appellate court will consider them. Under such a process, a trial judge can determine the outcome of a trial with impunity. Chapter 43, the en banc court overturns the appellate court. The decision of the 11-judge panel was to overturn the 3-judge panel and to support Judge Talman's trial court decision. The vote was 7-4. The opinion written by Judge Bay was filed November the 5th, 2009, and dissent was by Judge Fletcher. The judges who disagreed with the conclusion of Judge Bay were Fletcher, Pregerson, Wardlaw, and Paez. In his dissent, Judge Fletcher restated the entire case, just as Judge Bay in the majority opinion. The government maintained in its opening statement to the jury that Swisher was a Korean War combat veteran, and it maintained throughout the trial that Hinkson's understanding of Swisher's military exploits showed that he was serious in his solicitations of Swisher. The government now concedes that Swisher neither served in combat nor earned any personnel military commendations, and that Swisher presented a forged military document in court and repeatedly lied under oath at trial about his military record. Hinkson makes 3 arguments on appeal. First, he argues that the district court wrongly excluded documentary evidence showing that Swisher presented a forged document and lied on the stand. Second, he argues that the prosecutor engaged in misconduct when he invoked Swisher's military service in his closing argument, despite having substantial reason to suspect that Swisher had lied about that service. Third, he argues that the district court abused its discretion in denying his motion for a new trial upon his discovery after trial of new evidence conclusively establishing that Swisher had lied on the stand. I would reverse the district court's based on Hinkson's first and third arguments. I would hold that the district court abused its discretion when it excluded documentary evidence that would have contradicted Swisher's claim on the stand that he was a decorated combat veteran, and I would also hold that the district court abused its discretion when it denied Hinkson's motion for a new trial. We review for abuse of discretion a district court's evidentiary rulings, including decisions to admit or exclude impeachment evidence. We must then apply the harmless error standard. We will reverse on evidentiary ruling for abuse of discretion only if such non-constitutional error more likely than affected the verdict. United States v. Edwards, bunch of numbers. Harmless error, any error, defect, irregularity, or variance that does not affect substantial rights must be disregarded. Hinkson sought to introduce the Tolbert letter, the Dowling letter, and the rest of Swisher's official military file in order to show that Swisher lied about receiving the Purple Heart and his other claimed military decorations, and to show that he had forged his so-called replacement DD-214 that he had brandished before the jury. The district court excluded this evidence based on Federal Rules of Evidence 608B. 403. Rule 608B provides specific instances of the conduct of a witness for the purposes of attacking or supporting the witness' character for truthfulness other than conviction of crime, as provided in Rule 609, may not be proved by extrinsic evidence. They may, however, in the discretion of the court, if probative of truthfulness or untruthfulness, be inquired into the cross-examination of the witness concerning the witness' character or truthfulness or untruthfulness. 2. Concerning the character for truthfulness or untruthfulness or of another witness as to which character the witness being cross-examined has testified. The district court deemed the documents bearing on Swisher's military experience and extrinsic evidence probative of a specific incident of untruthfulness and therefore inadmissible under Rule 608B. The district court erred as a matter of law in holding that the Tolbert letter, the Dowling letter, and the other documents in Swisher's file could be excluded under Rule 608B. The 2003 Advisory Committee notes to Rule 608 make clear that the absolute prohibition on extrinsic evidence applies only when the sole reason for proffering that evidence is the attack or support the witness character for truthfulness. Fed R. Evid 608B Advisory Com Notes 2003. Hinkson did not seek to introduce those documents for the sole purpose of attacking the witness character for truthfulness. Rather, Hinkson sought to introduce the documents for the specific purpose of contradicting in-court testimony by Swisher. Such evidence is governed by Rule 607, which permits courts to admit extrinsic evidence that specific testimony is false because contradicted by other evidence. United States versus Castillo, a bunch of numbers. Swisher took the witness stand wearing a Purple Heart lapel pin, thereby affirmatively stating that he had been wounded in combat while serving in the United States forces. Rule 801A provides a statement as nonverbal conduct of a person if it is intended by the person as an assertion. Recall that in his opening statement to the jury 3 days before, the prosecutor described Swisher as a combat veteran from Korea during the Korean conflict who was not adverse to violent, dangerous activity. Particularly given the prosecutor's statement, the jury could hardly avoid understanding Swisher's wearing of a Purple Heart as nonverbal conduct intended as an assertion that he had been wounded in military combat. The documents Hinkson sought to introduce would have directly contradicted that statement and would have shown Swisher to be a liar. The district court also erred by refusing to allow Hinkson to introduce this extrinsic evidence to impeach Swisher based on Rule 403. Rule 403 provides, although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The district court abused its discretion by concluding that it would be unduly time-consuming and confusing to the jury to admit the official military documents showing that Swisher lied about receiving a Purple Heart, and that when challenged she lied about having a so-called replacement DD-214. Although some parts of Swisher's military record may have been difficult for a lay jury to understand, other parts were easy to comprehend. For example, the Dowling letter was clearly written and unambiguous. It stated simply and directly that Swisher had not been in combat and had not been awarded any medals. Other documents in Swisher's official military file, which had been sent to the court pursuant to its subpoena and whose authenticity was not in doubt, unambiguously showed that Swisher's replacement DD-214 was a forgery. Given Swisher's crucial role in the government's case against Hinkson, the time it would have taken to admit this evidence could hardly have outweighed its probative value. The district court's refusal to allow Hinkson to admit this documentary evidence was not a harmless error. Swisher was the government's principal witness on the only counts on which Hinkson was convicted. The jury would have formed a significantly different impression of Swisher's credibility if Hinkson had been permitted to introduce evidence that Swisher lied about his military record on the stand. Hinkson's motion for a new trial asserted that Miller and Woodring affidavits newly obtained after trial proved conclusively that Swisher had presented false testimony and had presented a forged document during trial. The government had no longer disputes that Swisher lied about his military experience and presented a forged replacement DD-214. It contends, however, that newly obtained Miller and Woodring affidavits do not warrant a new trial. We review for abuse of discretion a district court's denial of a motion for a new trial based upon newly discovered evidence. A district court abuses its discretion when it makes an error of law, when it rests its decision on clearly erroneous findings of fact, or when we are left with a definite and firm conviction that the district court committed a clear error of judgment. United States v. Harrington, 410 F.3D 598, 9th Circuit, 2005. A criminal defendant must satisfy a five-part test in order to prevail on a motion for a new trial. The evidence must be newly discovered. The failure to discover the evidence sooner must not be the result of lack of diligence on the defendant's part. The evidence must be material to the issues at trial. The evidence must be material to the issues at trial. The evidence must be neither cumulative nor merely impeaching. And the evidence must indicate that a new trial would probably result in acquittal. The district court applied this Harrington test, citing Wagner. What we today call the Harrington test is sometimes referred to as the Berry Rule, named for the 19th century case from which it derives. C3 Charles Allen White, bunch of numbers. Although we ordinarily state the test as comprising 5 requirements, we have recognized that requirements 3, 4, and 5 are duplicative. That is, newly discovered evidence is material when the result of the newly discovered evidence is that a new trial would probably result in acquittal, a condition that is not usually met when the newly discovered evidence is cumulative or merely impeaching. Noting the materiality and probability requirements are really two means of measuring the same thing. Per curiam, noting that newly discovered impeachment evidence supports a new trial if it is likely that the jury would have reached a different result in light of the evidence. See also Wright et al. The charter of the defendant newly discovered evidence determines how strictly we apply the Harrington probability requirement. Our usual rule is that newly discovered evidence does not entitle a defendant to a new trial unless the evidence indicates that it is more probable than not that the new trial will result in acquittal. The rule applies to most newly discovered evidence, including newly discovered evidence tending to show that the evidence presented at the defendant's trial was false. I would conclude that the Hinkson has satisfied all 5 parts of the Harrington test. To my surprise, the majority concludes that Hinkson has satisfied none of them. Under the first part of the Harrington test, we must determine whether the evidence presented in support of the motion for a new trial is newly discovered. Hinkson's new trial motion relied on 2 new pieces of evidence. 1, the affidavit from Chief Warrant Officer Miller, the Marine Corps liaison to the National Personnel Record Center, and 2, the affidavit from Colonel Woodring, the officer whose purported signature appears on Swisher's replacement to DD-214 and supporting letter. It is undisputed that neither piece of evidence was known to or was in the possession of the defense until after the Hinkson's trial had concluded. The majority concedes that both Miller and Woodring affidavits are newly written evidence, but it contends that the affidavits did not provide any new information. We have sometimes applied a less demanding standard for granting a new trial where it is known conclusively at the time of the new trial motion that the evidence presented at trial was false, because I would hold that Hinkson is entitled to a new trial under the Harrington test. It is unnecessary to apply this test not already considered and rejected from evidentiary admission by the court. In other words, the majority concludes that the evidence contained in the documents is merely cumulative or evidence that was already known during trial. The argument is best addressed to the 3rd Harrington requirement. The majority's conclusion would be more persuasive if the district court had not indicated clearly during trial that, in its view, the evidence then before it was insufficient to show that Swisher had lied about his military record. After reading the half-inch thick of file received on January 21st from the National Personnel Record Center, which concludes the Dowling letter, the district court stated, "It is not at all clear to me that what the truth of the matter is." The court indicated that the file was very difficult to decipher and not self-explanatory. The court stated that it could not resolve its uncertainty without hearing a military records custodian or similar person. The prosecutor added that what was needed in order to show the falsity of the replacement DD-214 was an affidavit from Colonel Woodring stating that his signature had been forged. As I will discuss in more detail below, the newly provided Miller and Woodring affidavits were precisely the evidence that the district court and prosecutor on January 21st had described as fatally lacking. If the district court had not explicitly stated the evidence of the sort provided by the Miller and Woodring affidavits was needed to decipher the Swisher's file and to determine the truth, the majority's conclusion that this evidence is merely cumulative might be understandable. But the district court's explicit statements that it needed precisely this evidence makes it impossible to conclude that the substance of the Miller and Woodring affidavits was not new. Diligence under the 2nd part of the Harrington test. We ask whether the failure to discover the evidence sooner resulted from a lack of diligence on the defendant's part. See Kolsuk. Whatever. A court cannot conclude that a defendant lacks diligence merely because a defense team with unlimited time and resources might have managed to discover the evidence sooner. Instead, a court must ask whether it was unreasonable for the defense to have failed to discover the evidence more promptly. All that is required is ordinary diligence, not the highest degree of diligence. The district court concluded that Hinkson had not been sufficiently diligent in discovering the new evidence. It wrote, "The court finds that the defendant is unable." Okay, I'm at the top of page 301. Give me just a second. Give me just a second. Okay, I think we're done. We're going to start on the top of page 301. All right, we'll start at page 301 next.